A federal judge presiding over a civil lawsuit involving the January 6th House Select Committee ruled yesterday that former President Trump and his legal advisor, John Eastman, likely committed federal crimes in their effort to block the certification of the 2020 election results. In a 44-page decision about whether the committee should receive some of Eastman's private communications, the judge wrote in part this: the illegality of the plan was obvious. Based on the evidence, the court finds it more likely than not that President Trump corruptly attempted to obstruct the joint session of Congress on January 6, 2021. The judge's comments mark a significant breakthrough for the committee investigating the Capitol attack, which is weighing whether to make a criminal referral to the Justice Department. It's important to note the ruling has no direct bearing on whether Trump will face criminal charges, and that it involved a civil case in which the burden of proof is less than in a criminal case. Trump did not respond to a request for comment.
Let's bring in right now attorney George Conway and congressional correspondent of the Washington Post, Jackie Alamany. Thank you all so much for being with us. Let me start with you, George. I mean, does this really matter? In the Mueller report, you had prosecutors, investigators there. Oh yeah, sure, he committed a crime. I mean, basically what they said, if he wasn't president, he would be they'd go after him. You had Manhattan DA scuttle an investigation when the prosecutors say he committed multiple crimes. Now we have a federal judge saying yes, he committed multiple crimes. Does it really matter? Does Donald Trump gets away with everything? Is he going to get away with this too?
Well, I can't tell you yet whether he's going to get away with it, but it does matter. I mean, this is a federal judge making these findings independently on the basis of evidence that's just, overwhelming. I mean, what the judge found here was that there was a likelihood that Donald Trump and John Eastman violated two federal statutes that essentially do the same thing. They essentially prevent people from corruptly or fraudulently interfering with the official proceedings of the U.S. government and from interfering with the official lawful functions of the U.S. government. And in both, with both statutes, the evidence the judge listed here, which is now public and we've been discussing it for quite some time, is overwhelming. That yes, they were trying what they were trying to do was to conspire to stop the counting of electoral votes pursuant to the 12th Amendment of the Constitution and the Electoral Count Act, and they were trying to do it through lies and deceit. And the thing that the defense that Donald Trump is going to have, or he's going to try to use, is that, oh, I really believe this. I really believe this. But the evidence, again, gone through here very systematically by the federal judge, is that he had every reason not to believe that he won the election. He was told this by the Cybersecurity and Infrastructure Agency of the Department of Homeland Security. He was told this by the Attorney General of the United States, who he made look into this. He was told this by people in the Justice Department who followed Barr, Mr. Rosen, the acting Attorney General, and then Donahue, the acting Deputy Attorney General. He was told by the White House counsel that his attempt to overturn the election was folly. He was told by Raffensperger, the Secretary of State in Georgia, and I would add, it wasn't in the opinion, he was told this by the Senate Majority Leader, Mitch McConnell. And he lost 60 lawsuits. All of these things makes it impossible to believe that he didn't know that he was committing a fraud. And his defense is basically, the bigger the lie, the more I should get away with it. And the other thing was that we did this out in the open. Well, you don't destroy democracy in secret. It has to happen out in the open with big lies. And that's what the history teaches, and that's what we saw leading up to January 6th.
So, George, as strong of a case as the Justice Department would have against Donald Trump, according to this judge, if they went after him, looks like Eastman, the case against Eastman may be even stronger because of his words and deeds. Talk about Eastman.
Yeah, Eastman, I think the judge, without saying so, confirmed the wisdom of Eastman's lawyers, who told him to plead the Fifth, and he pled the Fifth 146 times at his deposition before the January 6th committee. He's seriously exposed because he was the point man for all of this. He was the one coming up with the legal theories and passing them around and trying to persuade others. And in fact, in some of the documents, it appears that he acknowledged that there was no precedent for what he was arguing arguing. His own bad faith is revealed in his documents. So he's an even, and as a trained lawyer and law professor and a former Supreme Court clerk, he knew better than Trump had to.
Manny, I want to hear about other moves being made by the January 6th Select Committee. Are they making any headway in terms of getting toward presenting to the public a clear case?
They are moving in that direction at the moment. We saw last night the committee take their most recent definitive step forward, moving to hold Dan Scavino and Peter Navarro, two close aides to the former president, in criminal contempt. That'll then get a full vote in the House before being referred to the Justice Department, which will have to ultimately decide whether or not they're going to pick it up for prosecution. But there are a bunch of loose ends that the committee has to deal with right now before they move to the public phase of hearings. And as Congresswoman Liz Cheney, the vice chair of the committee, told me last night, there is still a lot of work to be done, despite public hearings being scheduled to start in about 1 or 2 months. And that includes people like Ivanka Trump, Congressman Scott Perry, Jim Jordan, House Minority Leader Kevin McCarthy. Jared Kushner is appearing on Thursday. Now Ginny Thomas is another moving piece of this puzzle. So there are some really key people, including Mark Meadows as well. The Justice Department has yet to make a decision on whether or not they are going to prosecute him for the criminal contempt charge. You could see those frustrations boiling over. But as committee members noted last night at the contempt hearing, hundreds of interviews have been held, hundreds and thousands of documents have been obtained. So they are on their timeline and they're on track to hold those public hearings later this spring.
Hey, Jackie, you've got some new reporting up just this morning about Ginny Thomas, of course, the wife of Supreme Court Justice Clarence Thomas, and those text messages, those exchanges she had with Mark Meadows as she sought to help overturn the results of the 2020 election and help the White House stage a coup. What more are you hearing about reaction from Democrats? The Senate Judiciary Chair Dick Durbin told NBC News yesterday he believes Clarence Thomas needs to recuse himself based on these texts from any further review by the Supreme Court of what happened around the election. What are you hearing today?
Yeah, we have fresh reporting this morning responding to Bob Costa and Bob Woodward's reporting about Ginny Thomas's text exchanges with former White House Chief of Staff Mark Meadows and Senators Elizabeth Warren, along with a handful of other lawmakers, including Senator Sheldon Whitehouse, who is the chair of the Senate Judiciary Committee, and Pramila Jayapal, and a handful of other Democrats in the House are ramping up pressure on the Supreme Court, on Chief Justice Roberts and Clarence Thomas for Thomas to recuse himself from any January 6th cases going forward, to provide a written explanation for why he failed to previously recuse himself. Remember, he was the one Supreme Court justice who wanted to block Trump's documents from the National Archives from providing documents to the January 6th Select Committee, and also for Justice Roberts to provide a code of conduct, ethics for Supreme Court justices going forward, so that there is more of a system for them to actually state conflicts of interest and act accordingly.
Hey, George, good morning. Jonathan Lemire. Former President Trump yesterday put out a detailed statement in the wake of these allegations in which he went on about a golf shot, an alleged hole-in-one that he hit, and spent a lot of time on that. But give us your sense here in terms of what this could mean for the January 6th committee. Like, in terms of what opening do they have here, both in terms of the public relations and the politics, but also the legal aspect of this. And as Washington waits, what is Attorney General Merrick Garland waiting for?
Well, we don't know what he's doing. I mean, and it's possible. I mean, he promised in his speech, Attorney General Garland, back in January, that he would be working his way, or this Justice Department will be working its way up the chain in the way they do in organized crime cases, and they will follow the evidence wherever it leads. I think that the big result of yesterday's decision is that it just reemphasizes that the evidence ultimately leads to the Oval Office. And I don't have any reason to believe that Judge Garland won't be doing that. On the other hand, if there were more direct proceedings looking into that, even grand jury proceedings, witnesses would begin to talk and we'd start to have news stories about people being called into a grand jury. All that said, it's not such necessarily a bad tactic for the Justice Department to allow the January 6th committee, which has been doing a yeoman's job of collecting some of the evidence and then studying it as it comes in. So, I think I hold out hope that this will actually lead to some action. And I think it's important that it lead to some action, or at least a determination as to whether or not a prosecution could be made, because this is what we have. This is the way we have to defend our democracy. I mean, we don't have to take up arms and learn how to use rocket-propelled grenades to defend our democracy the way they have to do in Ukraine. The way we do it here, because we have a functioning court system, and it's not an external threat; it's a domestic threat. What we have to do is enforce the laws that exist on the books. And there are, if there ever was a conspiracy to defraud the United States about something, I mean, $1 million, $1 billion, that's usually money in these cases, but this was our democracy. This was the whole kit and caboodle. If these laws don't apply here, they don't apply anywhere.